Recently, a subscriber asked me to do a little bit deeper of a dive into what exactly executive orders are. And so today we're going to look at executive orders, their history, how they've been used, when they've been overturned, and why. And in addition to that, we're going to contrast them with something that came up during the Bush administration called signing statements. So stay tuned. This should be a good one. Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. So, what is an executive order? An executive order is a directive issued by the President of the United States that manages operations of the federal government. It has the force of law, but it doesn't require approval by Congress as long as it is tethered to the President's constitutional or statutory authority. What is the purpose of an executive order? Well, it's designed to do three things. One, it's designed to implement laws. It facilitates the execution and enforcement of existing laws if the president tells the distant agencies, the Department of Justice, for example, or the Department of the Navy, how it wishes to have a particular order or a particular law enforced, what they should do, how they should use their discretion, and more importantly, when should they not use their discretion. And then it sets policy direction. Now, you may recall that one of the more, I would say, controversial issues that arose was the fact that President Trump said that from this point forward, there's only going to be two genders in America, male and female. For probably 15 years ago, that would not have been particularly controversial, but now it seems to be somewhat controversial. Now, the third way that they're used is in national security and national emergencies. They can be used to address urgent issues that require the president to cut through red tape and get emergency action going. So, again, national emergencies and security threats sort of fall into the situation where the president is acting under his war powers or commander in chief powers. Now, what are the preconditions for issuing an executive order? First, it has to have a legal basis. It has to be grounded either in the Constitution or in the president's statutory authority. For example, the Immigration and Naturalization Act gives the president certain powers to remove unwanted people from the United States. Whether you call them undocumented or illegal aliens, that's the purpose of having the president having discretion. He can essentially direct the people who enforce that, which is Homeland Security. He can direct them in how to use their discretion. And clearly, he has been using the discretion to get rid of the criminal aliens first. So again, it sets some policy as well as being tied to the statutory basis for issuing that order. What is the scope of authority? Well, it is limited to the executive branch. You can't use an executive order to create new laws or appropriate funds. Those powers are reserved for Congress. So if you don't have enough money to build the wall at the southern border, you can't order by executive order the Congress to give you more money. You have to ask Congress to give you the more money. That's, again, separation of powers doctrine coming into play in how all of these things work together. So, what is the historical context of executive orders? Well, the very first executive order was issued by the very first president of the United States, President George Washington. Washington's first executive order in 1789 directed the heads of the executive departments, Secretary of State, Secretary of War, because they didn't have a Defense Department then. He directed them to submit reports about their operations. This was part of Washington's efforts to establish procedures for government operations. Now, that order was never challenged in court as it was administrative in nature and Nobody really thought of it as being particularly controversial. But there have been executive orders that have been fairly controversial. One of them was the Emancipation Proclamation. It was issued by President Abraham Lincoln on January 1st, 1863. Now, I don't think today anybody questions whether or not emancipation of the slaves was the right thing to do, but at the time, even people in the North questioned whether the president had the ability to do this. The Emancipation Proclamation declared the freedom of all enslaved people in the Confederate held territory during the Civil War. Lincoln justified the proclamation as a war measure under his powers as commander in chief. It was not explicitly tethered to a constitutional provision or a statutory provision. It simply said that under the war powers, he was doing this. And he was doing it because the Confederacy was using slave labor in support of its war effort. By removing the source of that labor and essentially guaranteeing that those slaves who escaped could not be sent back, President Lincoln intended to undermine the logistics of the Confederacy. He also probably intended that as a moral statement, but certainly in terms of its legality, he tethered it to the Constitution and to the war powers. A challenge to that order might have focused on the fact that at the time slaves were not human beings, as sad as that is to say. That was the Dred Scott decision. They were property, and it could be viewed as unconstitutional taking for him to declare them free. At that time, however, the Union was squarely behind Lincoln, and it's doubtful anyone would have had the temerity to challenge that order in court. The Emancipation Proclamation was never directly challenged. Its legality was widely debated, but the end of the Civil War put an end to that because there were three constitutional amendments, the 13th, 14th, and 15th, which were designed to eliminate slavery. Now, the 13th Amendment, explicitly outlawed slavery and servitude. The 14th Amendment, however, established due process and extended due process, I should say, to the states, and also set about giving people equal protection of the laws because the slaves were thought to be, kept under a system that would never allow them to really be free. So this was an attempt to really make them free. And essentially, the 13th, 14th, and 15th were intended to eliminate the trappings of slavery. Now, executive orders have a long history, and as you can see, it's a pretty storied one. But it wasn't until halfway through the 20th century that the first effective court challenge was mounted to an executive order. That was in Youngstown Sheet and Tube Company versus Sawyer, a 1952 case at the Supreme Court. The case is often referred to as the Steel Seizure case, and it's a landmark decision in constitutional law that addressed the limits of presidential power. Here's the historical background and motivation behind President Truman's executive order in that case. After World War II, the U.S. was navigating a complex economic landscape. It was trying to transition from a wartime footing of production, and it was dealing with inflation, where the government had dumped all of this money into war production, and there were a lot of labor disputes that went with that. During the war, everybody pitched in and pulled together, and nobody complained. But after the war, people started wanting their piece of the prosperity that was supposed to come. But that all ended in 1950 with the Korean troops overrunning the South Korean peninsula and the United States and the United Nations troops being sent there to push them back. That placed additional demands on the U.S. economy, particularly on industries vital to defense like steel. The steel industry was essential for producing weapons and other military supplies needed for the Korean War. Every tank required steel. Every shell fired at the enemy required steel. Even Army helmets required steel. However, in 1952, the United Steelworkers of America announced their intention to strike due to unresolved labor disputes over wages and working conditions. Now, think for a minute, if you will, if you've never been into a steel mill, can you imagine working in a place in the summer where iron ore is smelted at a temperature of 3,000 degrees Fahrenheit? The steel industry had not been kind to its workers, and there was a lot of animus generated by that. But a strike would shut down production across the industry, and Truman believed the steel industry was not negotiating in good faith. So his decision was simply that he would take it over. President Truman believed that a strike in the steel industry would severely disrupt production and compromise national security. So on April 8th of 1952, he issued Executive Order 10340 directing Secretary of Commerce Charles Sawyer to seize and operate the nation's steel mills to ensure uninterrupted production. Through the lens of history, Truman's actions now appear to be radical and disrespectful of private property rights. At the time, though, President Truman was worried about soldiers having what they needed to fight the war. The steel companies, as you might expect, challenged that order, arguing that Truman had exceeded his constitutional authority as there was no statutory basis for the seizure. Like Lincoln, Truman had war powers, and according to the Supreme Court, the order was not based on any specific statutory authority, but generally based on all the powers vested in the President by the Constitution and laws of the United States and as President of the United States and Commander in Chief of the Armed Forces. But of course, this order didn't directly go to the armed forces. The Supreme Court, in a 6-3 decision, ruled against the President. The court held the executive order was not authorized by the Constitution or laws of the U.S., and it could not stand. It said there was no statute which expressly or impliedly authorized the president to take possession of the property like he did. That doesn't mean that Truman didn't have some authority to deal with this issue. He had the authority to deal with this very issue through the Taft-Hartley Act. That was passed in 1947, 3 years previously. Section 206 of that act provides for presidential intervention, court injunctions, and an 80-day cooling off period to allow for negotiations where the strike is halted and employers cannot retaliate during that time. The Supreme Court noted that in its consideration of the Taft-Hartley Act in 1947, Congress refused to authorize governmental seizures of property as a method of preventing work stoppages and settling labor disputes. And it is further said that the authority of the president to issue such an order in the circumstances of that case cannot be implied from the aggregate powers under the Constitution, including the war powers. So, without saying as much, they essentially said that President Lincoln's basis for the Emancipation Proclamation was on somewhat shaky footing. But of course, by then it's ancient history. The decision emphasized the principle of separation of powers and the need for presidential actions to be grounded in either constitutional or statutory authority, and so Truman, it would appear, overreacted. The Youngstown case underscored the limits of presidential power, reinforcing that the president can't act unilaterally in areas where Congress has specific legislative authority. It remains a pivotal case in discussions of executive power, often cited in legal arguments concerning the extent and limits of presidential authority. Now, history shows how executive orders have been used to address immediate needs and shape policy, often reflecting the priorities and challenges of their times. Past executive orders and their challenges set important precedents that influence future actions and judicial interpretations. Historical challenges underscore the importance of checks and balances in the U.S. system, reminding us of the judiciary's role in curbing potential overreach. Now, one area where executive orders are frequently misunderstood is in the area of signing statements. Some people believe that a signing statement is an executive order, but it is clearly not. But it's frequently misunderstood as one because people often try to use it as one. It is a written comment issued by the president on signing a bill into law, usually one that he doesn't want to sign, and it outlines the president's interpretation or concerns regarding the legislation. It may suggest how the act is to be implemented, but it's not binding on any government agency. Executive orders, on the other hand, directly manage federal operations and enforce laws, while signing statements just provide the interpretation. The big difference is that if properly issued, subsequent to statutory or congressional authority, executive orders have the force of law within the federal government, and signing statements do not. So, executive orders are powerful tools for directing federal operations. They have been used since the very first president, but they've only become a source of litigation and concern more recently. There's some belief that EOs can be used to skirt congressional action, and when they do, that's when they are usually unconstitutional. So hopefully that history of executive orders and explanations of how they're used will be helpful to people in understanding where we're going with the Trump orders that have been issued, all 396 of them. I don't know who told him that he really ought to try to set a new world record for executive orders, but by golly, he seems to be one of those people who can do things that other people can. So that's where we're at. Thank you for watching this video. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.